Well, last week on Washington Watch, I discussed at length the National Defense Authorization Act and how its current version, as I said earlier, waters down the terrific language that the House put in back in July. Now, there's opposition building to the NDAA in the House, but it's not so much over those issues I just mentioned as it is extending the authorization of Section 702 of the Foreign Intelligence Surveillance Act, or FISA. And this has garnered a lot of opposition. In fact, some reports are saying that at least 50, as of right now, are opposed as Republicans. Now, Section 702 opens the door for warrantless backdoor searches of Americans' electronic communications. Now, why has such important legislation been tagged and added to the annual must-pass NDAA after, we work through the NDAA and all of a sudden this language is here? What is it? What does the FISA provisions do? How have they been misused, and can they be fixed? Joining me to discuss this is Ken Klukowski, a former senior counsel in the Civil Rights Division of the U.S. Department of Justice and a former special counsel in the White House's Office of Management and Budget. He has also litigated constitutional cases in the U.S. Supreme Court. Ken, welcome back to Washington Watch.
Thanks for having me, Tony.
So, Ken, walk us through, number one, the history of the Foreign Intelligence Surveillance Act, FISA, and how it came about.
Well, this all started when, with evolving technologies, the issue is that the Constitution draws a distinction between law enforcement on one side and military, and which includes intelligence activities on the other. It's a distinction between law enforcement and national security. Law enforcement is the domain of domestic policy. National security, whether it's military or whether it's diplomacy or whether that's the CIA, all of that belongs in the realm of foreign policy. And that balances the fact that on one hand, the framers of our Constitution and, for 200 years, statesmen from every political party and in all branches of government have understood that the world is a dangerous place. It's a broken place. But at the same time, domestically, we need a free society, one where the presumption is of liberty, where we're maximizing the rights and liberties of American citizens. And so FISA strikes a balance there in terms of, well, what about when you have national security needs, but they take place on U.S. soil? Like what happens if you have a foreigner who is on U.S. soil, whether it's a student visa or they're a guest or they claim to be on vacation or whatever. So it's a matter of how we bring these very serious surveillance capabilities and exercise them on U.S. soil in a way that does not cross the lines of constitutional protection that American citizens have.
So, this has become complicated, as you mentioned, because of technology. But I think this goes back to 1978 when FISA was first approved. But Section 702, again, looking to technology, kind of opens a back door for searches of Americans. So, how has that jeopardized this Fourth Amendment against search and seizure?
Well, recent studies, as lawmakers have looked into this, they found out that there have been literally hundreds of thousands, not hundreds or thousands, but hundreds of thousands of FISA search warrants that have been executed on Americans without a search warrant. And that has set off alarms all over, it really on both sides of the aisle, because the Fourth Amendment to the Constitution, part of our Bill of Rights, was to do away with the British practice of what are called general warrants, meaning general search warrants. And that was just that if the government was unhappy with someone in Great Britain, they could just say, go search that guy's house until you find evidence of a crime. And there were specific instances of abuses in the mid 1700s where this was all over the radar screen of the framers of our Constitution. And so that is why they put in the Fourth Amendment of the Constitution a requirement that that search warrants must only be issued if people can swear out specific facts showing probable cause that executing that warrant would unveil evidence of a crime. And it had to be specific rather than general. It had to be specific in what the crime was and what sort of stuff they're looking for precisely. And that if you couldn't get a warrant, if law enforcement could not swear those things out before a judge and get him to sign a warrant, then you could not invade that person's house or papers or search their person and invade their privacy. So it's a fundamental right under the U.S. Constitution.
So, Ken, what is happening under Section 702 of FISA, if I'm not mistaken, is that technology...
Yeah, well, yes, go ahead, please.
Technology is allowing the government to comb through this data without a warrant and without the individuals actually knowing that the government is looking at it. And if they happen to find something, then they can act upon it. Is that correct?
Yeah, that's exactly right. Because otherwise, under the normal criminal justice system, if government agents seize information about you that they couldn't have gotten without a warrant, that information cannot be used against you in court. So, I mean, this is a robust right. And in fact, and that's where we see the proposed reforms that are being recommended and debated right now as to whether to keep FISA the way it is, whether to reform it a little bit, tinkering around the edges with it, or as a bipartisan group of lawmakers voted out just in the past few days, including some of the most conservative members of Congress teaming up, believe it or not, with some of the most liberal members in Congress, seeking to bring these constitutional protections into the FISA process.
So FISA actually does have a very important national security component when it's utilized under the restrictions that we're talking about protecting American citizens, correct? Given what's happening internationally with terrorism and the threats to the United States?
Yes, absolutely. The world's a dangerous place. There's sin in the world. Of course, we talk about that all the time on your show. So especially for people with a biblical worldview, but also just patriotic Americans, who might not even be of a particular faith. It's just an understanding that the world is a dangerous place. And so we do need tools to be able to protect Americans.
We just need them to be used properly, and what's being proposed are guidelines, restrictions that bring this back, as I understand it, to its initial purpose and function, which protects the fundamental rights of Americans. Is that accurate?
That's my understanding, Tony. Yes, we're talking about a package of reforms that was just voted out of the House Judiciary Committee by a vote of 35-2. I mean, championed by a great American and a great friend of this show, Chairman Jim Jordan of Ohio, but with liberal Democrats joining on to this package as well. Only 2 members, both of them Democrats, voted against the reforms. Aside from that, Republicans and Democrats all voted for this, which, among other things, would require a search warrant for 702 searches, with a couple exceptions, like if there is an imminent threat of death or bodily harm, or if there's an imminent threat of like computer spyware, like whether it's Iranian or whatever malware in a computer system, that you have a couple escape valves there to be able to act in urgent emergencies. But if it's not an urgent emergency, then the cops need to take it to a judge, tell them what they've got, and be able to swear to those facts. And then a judge makes a decision as to whether there is probable cause that this would actually uncover evidence of a crime, as the Constitution commands.
All right, so Ken Klukowski, that brings us to the NDAA and this language being attached to the NDAA. Now, my understanding is it's been attached. It's an extension that carries it over into the spring, because there was a sense there might not be enough time to get this accomplished in the standalone bill that you just talked about by the end of the year, which the current authorization expires on. So does the language in the NDAA do anything more than just extend this for a few months?
Well, in my understanding is that this is a fluid and evolving situation right now. I mean, I know that the bill text is out, but what I've heard as recently as the past 2 hours is that before the NDAA comes to a vote, that there could even be the proponents of different types of reforms having the chance to argue it out, and that there might be a last minute modification of the language possibly to incorporate these reforms. And I'm told that there are lawmakers pushing hard to make that happen, because if this is going to be reauthorized, that they want to do it right.
Well, I would sense that I would think that that probably has to happen given the opposition that is present to a plain reauthorization of this language, even if it's an extension just for a few more months, because of the abuses that have how it's been abused by the Biden administration.
That's right. You're talking about hundreds of thousands of search warrants conducted by the federal government against American citizens, where no judge ever said that there was probable cause, that it would show an indicator of a crime. And there's different reform packages out there, but I think for those who support Chairman Jordan's reforms, they point out that even under some of these other reforms, the government could still search through Wi-Fi if you're on a public Wi-Fi network. So if someone goes to Starbucks or McDonald's or a hotel and they are on a Wi-Fi network that's not their own private home network, that even then you are outside the protections of this warrant requirement. And of course, so many of your listeners, as they go through about their daily lives, I mean, how often are they in places where they're accessing
Right.
public Wi-Fi?
Well,
and the idea would be you could lose your protections in a situation like that.
Well, wasn't this in part what they used to go after President Trump when he was a candidate?
When the facts are still coming out on that, but we have seen alarming abuses from several years ago through stories that we've all, of course, heard them, and we've gone through the election campaign, and now, of course, they're being discussed even again about warrantless searches that were going on from individuals who worked in the Trump administration or on the former president's campaign.
Yeah, I just think we've got to be very, very careful in what type of power we give to our government. And these fundamental rights that our founders recognized, they need to be protected at all costs because they're there for a reason. Ken Klukowski, thanks so much for joining us. Great to see you. Merry Christmas.
Thanks so much, Tony. Merry Christmas to you.